JTC 100, we are working through the media regulation lectures, and this is part 3. So today we're going to turn to more formal laws and the discussion of free speech versus libel. One type of speech that's not protected by the First Amendment is something called defamation. Defamation, the false communication that leads to unjustified injury of the good reputation of another. Let's start off with a legal expert talking about defamation and how it relates to libel and slander, which I'll explain a little more after she's done.
Remember what you learned in kindergarten, to tell the truth and be kind to others? Well, sometimes adults have trouble with those rules and say or write something that portrays another person, business, or government entity in a negative way. If the thing that is said is false, then it can be considered defamation, which has legal consequences. There are two types of defamation, slander and libel. Slander refers to a verbal statement that is both malicious and false, while libel refers to a written or graphic malicious and false statement. State laws do vary regarding the exact definition of slander, libel, and defamation within a particular jurisdiction, but in principle, it has been illegal since the country was founded. Most of the time, those accused of defamation stand trial in civil court and may be found liable for damages. However, a few states also allow criminal charges to be brought for defamation, though criminal cases for defamation are pretty rare in the United States.
Okay, so let's go over that again. One subterm to defamation is libel. So that's a false statement that can be seen or heard in some way. For example, something written or broadcasted images or some other display. Think of something that is published that holds a person up to ridicule or contempt or hatred or injures that person's livelihood, such as their business or occupation. And note the legal expert we just heard said that it had to be false and malicious, but that's really just for public figures, as we'll see. For common citizens, it really only has to be false. Now, slander, we won't talk about that quite as much because it really doesn't involve media. It's more of a false statement that can be heard more in a face-to-face situation, such as a speech. Again, for common citizens, it only has to be false. For example, if I write a story in the Collegian, that's our campus newspaper, that identifies you and says that you smell bad, well, that can be libel. It has to be published. But if I would stand in a classroom and I pick you out and I say, hey, that you smell bad, well, that can be slander. So let's focus on libel, which is something actually published. You cannot claim defamation, including libel and slander, if the statement is true. So that's how you might defend yourself in court if you're charged with something like libel, like you're a journalist who's charged, for being libelous. You would just say, well, what I published is true. You really do smell bad. I can prove that. Or if the person or the institution feels wronged in some way, if that person agrees to the publication that you put together. That is, I tell you I'm going to publish or say that you smell bad, and you say, sure, go ahead, publish it. And I would probably just need a record of you making that statement. Or if the publication was an accident, for instance, the institution didn't mean to publish that statement, so it wasn't libelous. So in other words, I was writing on my computer that you smell bad. Sorry to keep using you as an example. But I had no intention to publish that, and then an intern sits at my desk and forwards what I wrote to an editor, and then it accidentally gets published. That's something that's not really libelous. Or if the statement is made during court proceedings. Now, in court, the judge, the attorney, witnesses, the jury, they have what's called an absolute privilege to speak freely. So journalists can report on what is said in court, even though it might be libelous outside of court. If that wasn't possible, then we wouldn't be able to sort of report on what's happening in the courts, and that's an important part of our society. Finally, if a statement is made in a publication that's clearly an opinion piece, something like an editorial, food criticism, parody. Parody means imitating a style for comic effect. It's clearly not supposed to be taken seriously by a reasonable audience. Or a sports column, for example, the columnist might say, hey, the coach stinks, or this team is playing the worst it's played in a decade. That's okay as long as the journalists and the publication make it clear the statement is opinion or it's criticism, that it's not an allegation of fact. Okay, that's got to be clear on that. So let's look at an example that could lead to a libel charge, I think. Watch how this television journalist who's annoyed by this, looks like a slightly inebriated person, kind of careful on what I'm saying here. I don't want to be charged with libel. But look what this journalist does and what she says about this woman, and see if you think the journalist could end up being in trouble.
I do like how Troy talked about how the zombies out here, because basically what is left is the people walking around with this glazed look in their eyes and just stumbling. Like this one behind me. Hi, yes. How are you doing?
California.
Oh, very nice to meet you. You know,
49ers.
you're going to do you're going to do an interview with us?
Sure.
Okay, because we were just talking about here along Bourbon Street and the STD rate that's been going on here. And so how long have you had an STD?
I don't have an STD.
Oh, then why did you want to talk?
Oh my goodness. 'Cause I
Oh
just
my
wanna talk about
gosh,
you
I'm
guys.
so sorry.
Are you
It's nothing
serious?
to be ashamed of right now.
No, I don't have an STD. That's
Oh,
so
okay,
disrespectful.
okay,
Oh my God.
yes.
It's bad. I have it.
Anyway, so I've been taking care of that in my own little way.
So you can see that the reporter is upset and frustrated, but boy, I mean, to sort of imply that this woman has an STD, that's really opening yourself up for libel. Something interesting that if you're a celebrity, if you're a well-known figure, if you want to charge libel, you also have to charge actual malice. Now, this woman, I'm assuming, is not a celebrity, this woman on the left. So she would not have to prove actual malice. And what that means is that the publisher of the statement knew the statement was false or very likely false. So if you're not famous and I publish a false statement about you, but I don't know it's false, that is, someone passed this information along to me and I didn't properly check it out or something like that, I can still be charged with libel. But if you're famous and I didn't know that this information was false and I publish it, I can't be charged with libel. That is not actual malice. For actual malice to have occurred, my famous accuser has to prove that I knew what I was publishing was false, but I maliciously published it anyway. That's actual malice. Now, there are other situations that keep public figures from suing for libel, even if what is published is clearly not true. And one case in point is the case of Hustler magazine versus Jerry Falwell. Okay? So what happened in this case was that the publisher of Hustler magazine, which is a pretty hardcore pornographic magazine, some years ago, the publisher Larry Flynt was charged with libel by the Christian evangelical leader, the Reverend Jerry Falwell. That was back in 1983. Hustler had printed an offensive ad parody that you see there that suggested that Falwell's very first sexual encounter was with his mother, and that event took place in an outhouse. So this is, I guess, meant to be a parody, right? I mean, it means imitating a style for comic effect, clearly not to be taken seriously by a reasonable audience. So this liquor ad here, there was a series of advertisements, by this company, but Falwell kind of takes those ads, which had this style, and then sort of inserts the story about Jerry Falwell that he made up. So I'm going to roll for you just a little bit of video from the deposition of Larry Flynt in this case, so you can get a sense of what he was like.
Are you known as Larry Flynt?
No, Jesus H. Flint, Esquire.
Have you ever called yourself Larry Flynt?
Used to, but it was spelled with an I then. F-L-I-N-T, now it's F-L-Y-N-T. I have 2 birth certificates.
Were you born in Kentucky?
No.
Have you ever served in the United States Navy?
I'm not sure.
Have you ever lived in Dayton, Ohio?
No, I was hatched in Dayton, Ohio. To the best of my recollection, the affidavit says that Mr. Farwell was at the age of puberty, thereabouts, and that they caught him in an outhouse looking at a picture of his mother and a Sears and Roebuck catalog.
So you kind of get the idea. I just wanted you to kind of get a sense that this guy Larry Flynt was a pretty harsh character. Some people didn't like him very much. And so it was interesting that a lower court ruled in Falwell's favor, awarding him $45 million to be paid by Flynt, by this guy, for emotional distress. Now, the Supreme Court, when it goes up there, overrules the decision, saying the piece was parody, and they believed it fell under the fair comment provision in libel law, that it was like an opinion piece or a sports column. So the decision led Flynt to proclaim, quote, "If the First Amendment will protect a scumbag like me, then it will protect all of you, because I'm the worst." But I want to end part 3 here, hoping that you understand that despite protections like this from the First Amendment, not all speech is protected. In one case in point is something called the Miller test involving obscenity. Another form of communication for which formal rules have been created involves what we call obscenity. And so in this case, a guy by the name of Miller, Marvin Miller, was operating one of the West Coast's largest mail-order businesses dealing in sexually explicit material. Here's what he did. In the early 70s, Miller had sent out a mass mailing advertising the sale of illustrated books, something he called adult materials. Now that was a light term. It was clearly pornographic. So they were these materials, which had a lot of pornography in them, were sent to just random addresses. He mass mailed out to a whole bunch of different addresses, including schools and daycares and hospitals and churches and just all kinds of households and things like that. And so some of it was quite upsetting to a lot of people. So this became an important United States Supreme Court case involving really what constitutes unprotected obscenity for First Amendment purposes. Miller, in this case, Miller was found guilty all the way up to the Supreme Court of knowingly distributing obscene material. The decision made clear that obscenity was not protected by the First Amendment and established what came to be called the Miller test for determining what was considered obscene material. Now, instead of me talking about this, I'm going to have Dr. Constance Penley kind of give some context to the case and kind of talk about what the Supreme Court ruled. Constance Penley is from the University of California, Santa Barbara. She is a professor of film and media studies at that school, specializing in film history and theory and feminist theory and cultural studies. And she's really well known on campus for her controversial classes on pornography. So let's listen to see what she has to say.
When Judge Potter Stewart said, "I can't define pornography, but I know it when I see it," that's the attitude that a lot of people have. They don't, in fact, think it's important to define pornography to discover what it really is. They think they already know it, and so they can go ahead and legislate it, regulate it, debate it, because we don't even have to talk about it. It's a given that there is something very, very wrong with it, that it's not just sexually explicit representation, it is obscene. That is, it has no First Amendment protection and can be banned. Whenever I start to teach the Miller test for determining what material is obscene in my classroom, the students have such an enormously difficult time getting their minds around most of the terminology in the Miller test. I mean, the first part of it, the two that speak to community standards, whether a reasonable person in the community would find the material to be appealing to prurient interests, or the second community standard, whether a reasonable person in the community would find the material to be patently offensive. And then the third, which is a national standard, does the material have any serious literary, artistic, political, or scientific value? And so my students immediately start going, what's prurient? And you try to explain, well, it's a bad relation to sexual materials. It's a morbid interest in sexual materials. And they go, well, what's that? And then they go, well, what's patently offensive? And isn't porn supposed to offend? Doesn't it have a lot of its challenge to sexual and moral taboos? And also, isn't it supposed to use lewdness and lewd humor to challenge political authority? So they just cannot even get their minds around material that could be attacked for vaguely appealing to a morbid interest in sex. What would that be? Your interest in sex, but not my interest in sex? And what's patently offensive when porn is supposed to be patently offensive? I've come to realize that so much of what people object to in pornographic materials is not that it challenges their moral values, their religious values, but that they just think it's in bad taste. And they think that whatever taste they have is, of course, superior taste.
Yeah, so as Dr. Penley really makes clear, you can make these laws about things like obscenity, but they're almost unenforceable because we all have sort of relatively different values, and one person's bad media is another person's artistic media. So it's really difficult to regulate these sorts of things. So that's the end of part 3. Part 4 is next.